So I want to just quickly introduce myself. I'm Stacey Livingston. I am a clinical fellow and one of the supervising attorneys at the Media Freedom and Information Access Clinic, or the Mafia Clinic, here at YLS. The Mafia Clinic specializes in advocacy work to defend and advance government transparency, democracy, and the freedoms of speech and the press. Historically, a lot of our work has touched on questions related to public access to information. And one of the key tools for getting that access is the Freedom of Information Act, which is what we're here to talk about. We're so fortunate to have two tremendous panelists to talk you through the basics of how to use FOIA effectively and to share some of their vast experience with you tonight. We're really, really grateful to both of them for joining us. I will give a quick intro of the two folks you're going to hear from. Joshua Eaton is an investigative reporter at Hearst, Connecticut Media Group. Before joining Hearst, he was on investigative and enterprise teams at NBC News, CQ Roll Call, and Think Progress. He uses FOIA frequently in his work and regularly gives presentations about how to get public records from state and federal agencies. And Sarah Normand is an attorney who spent more than 25 years litigating and supervising FOIA cases on behalf of a wide range of federal agencies. Until recently, she served as the deputy chief of the SDNY Civil Division, where she developed particular expertise in FOIA and other litigation involving sensitive government information. She briefed and argued dozens of cases in both district court and the U.S. Court of Appeals for the Second Circuit, and served as the principal supervisor and liaison for FOIA cases filed in the SDNY. In that capacity, she occasionally litigated against the Mafia Clinic, so it's a real treat to get to benefit from her vast expertise and to get to spend some time together when we're not on opposite sides of the V. To give you a quick sense of the run of show for tonight, FOIA Bootcamp normally runs for about an hour and a half. Our panelists will be covering some prepared material for the first hour or hour and 15 minutes. Then we'll leave some time for Q&A with them at the end. Feel free to send questions to me or into the chat at any time. I'll collect them for discussion when the time comes, and I'll use discretion about whether to save a question for the end or whether to try to interrupt our great panelists and ask it live. So with that, I will turn it over to Joshua and Sarah. Thank you both so much.
Thank you.
Thank you.
Thank you so much, Stacey. We're delighted to be here with you this evening, and I particularly want to thank the Mafia Clinic for the invitation. I've really enjoyed working with you as adversaries and colleagues over the years, so it's great to be here.
Thank you so much. I also brought a couple of FOIA suits, but they were both in the District of Columbia. So I think Sarah and I did determine that we were never on opposite sides of a case.
I'll get us started with just some very general description of the Freedom of Information Act. FOIA is the Federal Freedom of Information Act. It was first enacted in 1967, but it's been amended many, many times since. Most recently, in 2016, there were a number of substantial amendments made to the statute, including, as something that we're going to discuss, adding a new requirement for the government to withhold information. We'll get to that later, but recent changes have made it even easier for requesters to obtain information under the FOIA. The Freedom of Information Act allows pretty much any member of the public to request and obtain copies of non-exempt agency records. We're going to talk about what that means, but essentially you can request and obtain from any federal agency records that are not exempt from public disclosure under one of FOIA's 9 exemptions. The overall policy and purpose of FOIA is to keep citizens informed about what their government is up to, while at the same time protecting information that the government has a legitimate interest in maintaining as confidential. I've seen over the course of my career, many FOIA cases in litigation that have really very substantially furthered public understanding of how the government operates, what policies it has adopted, and why, really come about because of requesters who sought information under FOIA and litigants who were willing to go to court in order to obtain it.
Yeah, and we'll talk about state laws more in detail later, but federal FOIA applies to the federal government. Each state and the District of Columbia all have their own individual FOIA laws. Those apply to state and local governments, as well as some sort of quasi-governmental agencies.
Okay, so as I said, FOIA requests can be made of agencies. The statute itself contains a definition, which is identified here. But the general rule is that any agency of the executive branch can be FOIA'd. You can submit a request to any agency in the executive branch. The FOIA does not apply to Congress. It does not apply to the courts. It does not apply to the president, nor does it apply to specific components within the executive office of president whose sole purpose is to advise or assist the president. So we're talking about really the president's close advisors, like the individuals who are in the White House office or the National Security Council. But leaving aside those very relatively few components within the EOP, really any agency within the executive branch of the United States government can be FOIA'd. We have a question here. What about the Department of Government Efficiency? So DOGE, as you all, I'm sure, are aware, was created by executive order when President Trump took office as president for the second time in 2025. The way that the Department of Government Efficiency, DOGE, was created by executive order placed it within the part of the EOP, part of the executive office of the president that was intended to advise and assist the president, according to the government. But many FOIA requesters have submitted requests to the DOGE to seek records on the theory that really they are acting within agencies and doing much more than just assisting the president and advising the president. And so that is a question that really is currently unresolved. There are a number of FOIA cases that are still pending where the government has argued that DOGE is not an agency, rather it's a presidential component of the EOP. But but requesters are making the argument and have had some success in that argument that DOGE is actually an agency subject to FOIA. That's a question that's to be determined by the courts.
Yeah, state laws vary on who they cover. Here in Connecticut, we're very fortunate. Many state laws cover the governor's office. Connecticut, it covers the legislature. That's not true in every state. In Connecticut, it covers some judicial records that are administrative. And as I said before, it covers quasi-governmental entities, like, for example, the Yale University Police Department here in Connecticut is covered by Connecticut's FOIA law. That's different from state to state. Massachusetts, different case law. Their state FOIA law does not cover private police departments, but here in Connecticut it does.
So then the next question is, what is an agency record? Because under FOIA, only agency records can be FOIA, can be obtained under the statute. Essentially, the agency must have either created or obtained the record, and the agency must be in control of the requested materials at the time the FOIA request is made. The Supreme Court has elaborated on that test a bit. Essentially, what in control means is that the record has come into the agency's possession in the legitimate course of the agency's duties. But record is really very broadly defined under FOIA. It includes all kinds of documentary information, memos, emails, reports, letters, data that comes from government databases, photos, videos, maps. I see Joshua added computer code. Have you requested computer code under FOIA?
I have not, but I know people who have.
Yeah. Sound recordings, really anything that you can think of that's a piece of documentary information can be sought under the FOIA. It doesn't include, FOIA, a record does not include physical objects that are not reproducible. And you can't just ask questions under FOIA. You can't send a FOIA request asking an agency to answer a particular question, to compile a particular list of information, or to create documents that the agency has not already created. Those are really the only limitations. Otherwise, record is extraordinarily broadly defined under the statute. And beyond that, a FOIA requester can ask for records not only in the form that they were originally created, but also in any form or format requested by the person if it's readily reproducible by the agency in that form or format. So the FOIA is really quite pro-disclosure when it comes to the definition of record and the form of the record that can be requested. One thing that a FOIA requester really needs to think about and to be successful, a FOIA request really needs to reasonably describe the records sought. That's the legal requirement. The FOIA request must reasonably describe the records that are sought. And the courts have fleshed that standard out by saying that a professional employee of the agency, that's typically a FOIA processor, who's familiar with the subject area of the request, would have to be able to locate the record with a reasonable amount of effort. So, and Joshua's going to get into a number of different suggestions about how to do this. But really, a FOIA request is going to be much more likely to be successful if it's specific. If it specifically describes the kind of record that you're seeking, using keywords, using titles if you have it, talking about who the custodians might be, that is, who might have drafted the record, sent the record if it's an email, received the record. Providing date ranges is very helpful. Domains, record systems where the record is likely to be located. Really, you should think about what a FOIA processor, that is a person who's working at the agency whose job it is to process records, how would that person understand the request? Would that person understand exactly what kind of record you're looking for? And in this regard, you want to avoid ambiguous terms. You want to avoid asking, for example, for all records relating to or all records referring to, because that's going to be difficult for a FOIA processor to identify specific records. And it might be so broad that it sweeps in a huge amount of material that's going to take a very, very long time for the agency to process. We recommend not making broad sweeping requests for records because, one, it leaves the agency with an argument that the request is overly burdensome. And two, just as a practical matter, it's going to take a very, very long time to process if you ask for any and all records relating to broad topics of information. Another type of FOIA request that we've seen from time to time is all documents sufficient to show particular pieces of information. That also is going to be the type of request that's going to make it difficult for an agency processor to understand what exactly it is you're looking for. Try to be as specific and as reasonable in framing a request as you possibly can.
And I also just want to say, I think particularly for federal agencies, although for state and local agencies as well, but particularly federal, you should not assume that the person who's processing your FOIA request, reads the news about that agency or, has particular expert knowledge on the databases that you're looking at, or or how the agency processes certain kinds of things. And you want to do some of that legwork yourself, and we'll talk about that. So we'll talk about it a little bit more right now, in point of fact. How to file a FOIA request. Agency websites, whether that's a federal agency, a city, a police department, a particular office, will have info on how to file. Here in Connecticut, state government websites, this is Athena, my cat, she's going to make some appearances. Here in Connecticut, state government websites for agencies, they all have information on how to file FOIA requests. Police departments, city government sites, municipal sites usually do. If they don't, give them a phone call. Federal government agencies all have a dedicated FOIA site that will have this information. Many times, though not all times, they will direct you to some sort of online portal where you're filing your request. Anyone who files a bunch of state and local requests is well familiar with GovQA. There's different approaches to this. Some people file requests that are sort of set up with a bunch of legalese, assuming that they're going to litigate. I like to file really, I call them human readable requests, not lawyer readable requests. So I try to be short, light, clear, to the point, and eliminate as much ambiguity as I can when I'm filing the request. And the polite part is really important too. I try to always be polite and professional in my dealings with FOIA officers. Be specific, and we'll talk about that a little bit more. One really great rule of thumb, it's not always possible. More and more, particularly federal FOIA offices, make it very hard for you to get them on the phone. But it's really great, a day or two after you file a request, call them up and say, hey, filed this request. Does it make sense? Is it clear? Do you have any questions? Is there anything I can do to make it easier on you? Something I have done in the past is go a little bit broader in the initial request than I think I need to. And then I get to be like, well, I can limit this. And that buys you some goodwill with the FOIA office. Being organized is really great. I have a spreadsheet of FOIA requests that I've filed and that are outstanding. Is that sheet up to date right now? That information is redacted, but I do have that sheet. It's a really good practice. Some organizations, particularly journalistic organizations, have retention policies in their emails. So emails may automatically delete after a couple of months. In the FOIA context, FOIA requests can take longer than that. It's a good practice either to archive those emails if you have some sort of archive folder, or to create a PDF, so that then if it comes to appealing or if it comes to litigating, you have a copy of your request and you have a copy of any correspondence after that. So being organized is very important. And again, be persistent, but I like to say politely persistent. And politeness is the name of the game.
Before you move on, Joshua, I got a question in the chat that I think would be related to some of the stuff that actually both of you were mentioning, which is just about the agency's competency to address requests that are framed in legal type ways. And I'll publish the question. I think that's how it works. But the question is, isn't there going to be some competency in answering related to questions? Because in administrative law cases, that's the sort of thing that they need to do to produce an administrative record. I'm assuming that would be a federal law specific competency for administrative law cases. Is that something that you see agencies as being better at answering if requests are phrased that way? Or are those two things handled by completely different departments?
So I'll answer that from the federal side, having litigated both FOIA cases and APA cases, Administrative Procedure Act cases. So when you're talking about APA cases, where this is typically a case where the plaintiff is challenging a federal program or decision or regulation or the like, and an administrative record has to be created. The administrative record is supposed to include the materials that the agency considered in making the decision that's being challenged. And so there sometimes is dispute about what that record should include, but it would be subject matter experts at the agency who would put together a record and would be able to identify the material that the agency considered in making a decision. FOIA is different. FOIA is about seeking and the agency providing specific records that are requested by a requester. And there's a requirement, as I mentioned, that the request itself reasonably describe what records the individual is seeking. And so when you use records like words like related to, you're asking the FOIA processors and whoever he or she are talking to about the request to figure out not just what specific records are responsive, but what records might be related to the topic. And that's a much more difficult question, I think, to answer. If you think about what a typical processor might know, the typical processor might very well be familiar with the record keeping systems of the agency, but wouldn't have been typically involved in the underlying decision and be able to identify every record. Now they do have an obligation to go and talk to custodians and obtain information from custodians about where responsive records would likely be located, but it's a different scenario than in the APA, where the subject matter experts and the people who made the decision are tasked with actually compiling all the material that they considered in making a particular decision.
Just to follow up on that, I think, it's good to get down to the nitty-gritty of kind of how this operates bureaucratically. Like particularly in the federal context, less true in the state and local context, although still kind of true in the state context. But in the federal context, you are asking the FOIA office. Your request is basically like, hey, FOIA office, can you go talk to someone else in like a different part of this agency and ask them to give these records? So you're basically, it's like you're asking a librarian, like, hey, can you go get this thing from the archives? And the people who are processing that record, or that request, are not themselves the subject matter experts. They're going and talking to the subject matter experts. And particularly, if you file a request with the Department of Justice and you say, hey, I'd like any and all records that relate or refer to the indictment of James Comey. Are you asking for text messages between people who work in the canteen saying like, hey, can you believe this happened? Like, no. But those are, in theory, agency records that relate or refer to the indictment, right? So that's where specificity really comes in. So talking about specificity, I always tell people FOIA is step 2 or even step 3. It's not step 1. I'm a journalist. I'm often talking to other journalists. I say, you want to do some pre-reporting. And one of the hardest things, I think, for journalists when they first get into FOIA is it's a change of mindset. When you are making a FOIA request, as we've already said, you are not asking for, you're not asking questions, but you're also not requesting topics. You're requesting records, and making that mental shift from requesting topics to requesting records is really important. So one example I want to use here is a story I wrote back when I was at Think Progress, where I was able to show that the Pentagon had misled the Obama administration on a problem with gun background checks. This was in the wake of the Sutherland Springs shooting, and I believe 2018, where a man had walked into a church in Sutherland Springs, Texas, on a Sunday morning, opened fire, killed 26 people, and it came out that he had been court-martialed for domestic violence when he was in the Air Force, should not have passed a gun background check because that made him a prohibited person under federal law, but he was able to purchase guns legally because his background check came back clean. Came out that the Air Force never reported that court martial to the FBI, so those records could get into the gun background check system. And then it soon came out after that there'd been a series of like Inspector General reports and other findings that the Department of Defense in general was not very good at getting these kinds of records into the gun background check system. And so I want to just walk through how I was able to find this, and that's, I believe, on the next slide. So I had done a lot of reporting in the gun background check system. I felt like even though a lot of this had been reported, there was more reporting to do. I was reading an NPR story. That NPR story is at that bit.ly link you'll see right there. And in this NPR story, there was a reference to records submitted to Congress from the Attorney General. I don't do this all the time, don't do it very often, but actually reached out. It was sort of an oblique reference. I reached out to the NPR reporter, actually in a Twitter DM, and I said, hey, can I get more information on what these records are? I wasn't able to track them down myself. And the reporter said, oh yeah, it's this annual report that goes every year from the Attorney General to the Judiciary Committee. And I think, I can't remember if I reached out to Senate or House Judiciary. I reached out to one of the two. I reached out to the staff and I said, hey, can I get copies of these past reports? I got them. I read them. In the reports, there was a reference to this 2013 executive order that Obama had signed, I believe, in the wake of Sandy Hook, if I'm not mistaken. It required federal agencies to put together implementation plans. And these implementation plans were, are you getting all records you should be getting into the gun background check system? And if you're not getting those records into the gun background check system, how are you going to do better? Well, I read that and I thought, well, you know, hey, we have this new shooting that has to do with Department of Defense not getting records into the gun background check system. They were supposed to put together this implementation plan in 2013. I'd like to see that implementation plan because clearly they weren't following it. So that led down a whole other rabbit hole. I first FOIA'd DOJ for the DoD implementation plan. DOJ said, no, you got to FOIA DoD for this. And this can sometimes happen with these records that go in between federal agencies. Problem with the Pentagon is that FOIA is very decentralized in the Pentagon, and it can sometimes be difficult to determine which Pentagon FOIA office to submit your request to. So I spent probably about a day just trying to figure out, and this is after all this other stuff, just trying to figure out which office in the Pentagon, which FOIA office sort of had responsibility for this implementation plan that I was looking to get a copy of. Finally, I harassed DOJ. I was like, can you please tell me what office at DOD sent this to you at least? And finally, they told me. And I FOIA'd that office at DOD and was able to get a copy of the implementation plan. Turned out the implementation plan said, hey, we're getting all the records into the background check system that we should be. They weren't, as we saw from the shooting. And so I got a story out of it. Another example I want to give, and there's a video here, but I want to be conscious of time. So I'll just kind of describe this. After the Uvalde shooting in Texas, Governor Greg Abbott given a press conference where he'd given a bunch of information about the law enforcement response. It very quickly became clear that the information he'd given about that law enforcement response was not accurate. So 2 days later, he gave a second press conference where he said, listen, I'm livid I was given incorrect information before that initial press conference. He said I took handwritten notes on the information I was given, and that's what I conveyed at that press conference. That information I was given was not correct. So in Investigative Reporters and Editors, which is a great organization, we often talk about having a document state of mind, which means that when you're looking at an issue or when you're watching testimony before Congress or you're watching a press conference, be thinking about documents. And so immediately when I heard him say, I took handwritten notes on what they were telling me, and it turns out what they were telling me wasn't true, I thought, that's a record. Uh, Texas actually has a pretty great FOIA law. It applies to the governor. Filed a FOIA. I got a copy of the handwritten notes. Turns out they said exactly what he said they would say. My editors decided it wasn't a story. A couple of other local outlets had the exact same idea I did. They actually did write up stories that were just like, yeah, he was telling the truth. We decided to take a pass on that. But this was it's just an example of having a document state of mind, keeping your ears open for those documents when they come up. This is a fun example. Another example, I was, before I was here in Connecticut, I was in Washington, D.C., lived in Arlington, Virginia, my cat was sick. And so I was at the emergency vet on the weekend with my cat. I noticed they had a bulletin board where people would put pictures of their dogs. And a couple of the pictures were these things on the left here that looked like trading cards for canine police dogs. I saw at the top, National Geospatial Intelligence Agency. Well, that's a federal agency within DoD. So I thought, wait a second, that's an agency record. So I filed a FOIA request for copies of the trading cards, and got a call like the next day from the FOIA office. And it's the only time I've ever heard a FOIA officer be like delighted on the phone with me. And they said, hey, do you want scanned copies of these, or do you want like the actual cards? And of course I said I want the actual cards. And so I got like in the mail a stack of these trading cards for these canine dogs at National Geospatial Intelligence Agency's police department, and did a little fun story about them. I actually got to interview the chief of the department and one of the handlers too for the story. So it's a little light, fun story about these canines.
I'm going to jump in really quick, Joshua, just to say, I think your audio is coming in and out a little bit. I don't know if that's coming across to everyone else, but yeah, perfect. If you go to maybe that'd be better.
Can you hear me okay now?
Yeah, I think that sounds
excellent.
Better.
Anything I should repeat there?
I think it was coming through okay. It was just sort of a little up and down. While we're
paused,
though, I did
if that. I was just going to say, if that happens again, please feel free to jump in and let me know.
Okay, yeah, for sure. While we're paused, I'll ask this question that I got in the chat, which is just a clarification about what happens when an agency that is not subject to FOIA is communicating with an agency that is subject to FOIA, and whether somehow the involvement of the non-covered entity covers the whole record, or if you can still get it by going to the agency that is covered by FOIA.
Should I take that one, Joshua?
I have a couple of things to say on it, but I have a feeling you might say the same thing. So feel free to take a first swing, and then I'll jump in.
Well, the general answer is that typically you can still get the information or the records from the FOIA-able agency. So just to give you an example, even though there are components in the White House that are not subject to FOIA, they will often communicate with the agencies by email or through other records. And typically those communications are FOIA-able from the agencies themselves. You couldn't go to the White House to get them, but you might be able to go to the agency. Now, there may very well be exemptions that apply that would allow the agency to withhold the record for for one reason or another, including because it's privileged or because it's classified or some other exemption. We're going to get to exemptions later. But generally speaking, you can obtain records from agencies, even if they involve communications with Congress or the president. That said, there are certain limited circumstances in which records really originate. I'll give you an example. The Secret Service runs the process of logging visitors to the White House complex. And even though the Secret Service is an agency under FOIA and has White House visitor records because it creates them in order to protect the president and the White House complex, courts have held that because of separation of powers concerns, you can't FOIA the Secret Service to get what are effectively presidential records reflecting the president's visitors and schedules and the like. So, and similarly, if Congress provides a record to an agency and makes very clear that the record remains the property of Congress, and Congress does not, waive confidentiality of the record, there are circumstances in which the agency need not produce. That is not an agency record under FOIA, but those are relatively limited exceptions.
Most federal agencies will have a legislative affairs office that handles correspondence back and forth with Congress. I've had done some very fruitful FOIAs to legislative affairs offices. I remember this happening during the first Trump administration. There was a flurry of standing letters from congressional committees to agency legislative affairs offices saying, please consider, actually they weren't saying please, but they were saying, consider correspondence from our committee to be congressional records for the purposes of FOIA. I also want to say you can play both sides when it comes to, for example, joint law enforcement task forces, where there are federal and state law enforcement officers serving together on a task force. Let's say there's an email from state police to the FBI. You can FOIA both the state side and the federal side. That can be very fruitful. I've found situations where one side will redact something, the other side won't redact that. One side will respond more quickly than the other side does. That can be very, very fruitful.
The other point with regard to Congress is, although records that originate with Congress may very well not be agency records, there are often agency records that are created in response to requests for Congress or in preparation for testimony before Congress that very clearly are agency records. So there may be ways to request related agency records without having to address the records that Congress has deemed congressional.
And this is not on the question, but this is one thing on having a document state of mind and really, thinking in terms of documents and records that I want to say. And that's that anytime you see at a press conference or congressional testimony or in a tweet or wherever, anytime you see someone at an agency throw out a statistic, for example, this recent statistic that's come out of ICE about the percentage increase in assaults on ICE agents, the first thing that could come to mind is, oh, that means there's some sort of database. There's at least a spreadsheet that is, generating that statistic. There's some underlying data, and that underlying data is a record that I can FOIA. So, once again, just thinking in terms of document state of mind. Another thing I want to talk about is FOIAing other FOIAs. Are filing FOIAs on your FOIAs, something that sometimes gets called meta FOIA. An example I want to use here, again, you can go to the bit.ly link to see this story. This is a story I did at my current outlet, CT Insider and Hearst, Connecticut. You should all subscribe. It's a great outlet. This article was on how the head of the Yukon Police Sex Crimes Unit had been removed and demoted for alleged sexual harassment. And we'll go through the next couple of slides on how I found found this story. So the University of Connecticut publishes its FOIA logs online, which is great. It's wonderful. They do it almost in real time. And I often keep an eye on those FOIA logs. So I was looking through the FOIA logs one day, and I noticed up here at the top, you'll see Jennifer Mellon at the Office of the Federal Public Defender had filed a couple of FOIAs for personnel records and other records on this detective in the Yukon Police, Detective Mark Hanna. Of course, that piqued my interest, and I saw, I could click for more details. Saw this FOIA here, copies of all internal affairs and personnel files for Sergeant Mark Hanna. So after that, I filed the FOIA in the next slide, where I said, and you'll see that I was very oblique in the subject here because I knew the subject line would also appear in their FOIA log, and I didn't want other reporters to cotton on to what I was doing. So I, as soon as I saw this, filed a FOIA, or I just said, hey, this other person filed this FOIA, you gave them the records. I want the exact same records you gave them. This is a great thing to do, chiefly because the records have already been FOIA'd, they've already been processed, they're subject to FOIA, and the FOIA office probably has them on hand. So they're not going to have to go through the whole back and forth of trying to go somewhere else and wait for them to produce the records. They've already got them. So it's a very quick and easy way to do FOIA. So I said, hey, just give me the same records you gave this other person. They did. I got them. I got a story. And then actually before my story even came out, but then a flurry of them after my story came out, checked the Yukon FOIA logs, and sure enough, other reporters were FOIAing my FOIA because they wanted to get the same records I'd gotten and re-report my story.
So what happens at the agency when a FOIA request is submitted? The statute requires that the agency make a, quote, determination, quote, within 20 business days. This rarely happens within 20 business days, but that's what the statute requires. The period of time can be extended if the agency notifies the requester that within the 20-day period that exceptional circumstances necessitate an additional 10 days.
I don't think I've ever had an agency not have exceptional circumstances.
It's quite commonly asserted. The agency, what is a determination? What does that mean? It doesn't mean that the agency necessarily has to give you records within 20 days or even the 30 days if you get the extra 10, if the agency takes the extra 10 days. But it does have to determine whether to comply with the request. And in particular, whether it's not going to comply, it needs to notify the requester of an inability to respond. For example, these are not agency records that you're requesting, or we can't understand what this request is. The records aren't reasonably described. That gives the requester an opportunity to narrow the scope or to clarify exactly what it is that the requester is looking for. It's not uncommon for an agency to acknowledge receipt of a FOIA request within the 20 business day period, assign a tracking number, and in some cases they will say the agency is going to proceed to process your request. They may say, we'll process your request in the order in which it was received, and then you won't hear from the agency for some time, given that the agencies have very substantial backlogs at almost all federal agencies. But that is the first step on the agency side. If the agency does not respond within 20 business days or notify the requester that it needs an additional 10 days, that's considered what's called a constructive denial. In other words, a court would consider that to be a denial such that you can go straight to court. Generally speaking, under FOIA, you can't go to court without first exhausting your administrative remedies, which means giving the agency an opportunity to comply. But if the agency misses deadlines, does not respond within the 20 days or the additional 10 days, you can go straight to court. So if there's no answer, you can go to court. If the agency responds with either a denial of the request because it says these are not agency records, or this is too burdensome, or here's, in the rare case, here's the record, but we're redacting information, or if they give what's called a GLOMAR response, which is the type of response that says, we can't confirm or deny whether responsive records exist, because if we did that, just the mere existence of records or non-existence of records would itself be information that is exempt from disclosure because, for example, it's classified or privileged or subject to some other exemption. If you get a GLOMAR response or a denial or redactions, you can file an administrative appeal, and in fact, you must do that before you file a lawsuit in court. However, again, if the agency does not decide an administrative appeal within 20 business days, you can go to court on a theory of constructive exhaustion.
And one thing I want to say here very quickly is that federal agencies, I've never seen this at the state or local level, but federal agencies often have a two-track system where they have a complex track and a simple track. In the initial response, they should tell you which track your request has been slotted into. And, I get the temptation to, be afraid of missing something and so want to go broad. But one real benefit of going narrow and specific is, that complex track, it's complex requests, and you're then put at the back of the line, those complex requests. So if you can, do a narrow specific request that goes into that simple track, you're going to get something a lot quicker.
The other thing that happens at the beginning of the process from the agency's perspective is the agency has to make a determination of whether the request qualifies for expedited treatment. Now, expedited treatment is something that requesters can request when they file their FOIA request. And if you want expedited treatment, you have to include that request in the FOIA request. It's something that is applied very narrowly and not routinely granted. And that's because, generally speaking, agencies will process requests in the order in which they're received, sort of first in, first out, is how FOIA requests are typically processed. Now, as Joshua mentioned, many agencies have a simple versus complex track. So there might be a queue. There might be two queues where they're processing records in the order in which they're requested. But generally, you're going to have to wait your turn in line unless you make a request for expedited treatment and the agency grants that request. The agency has 10 days to decide the request for expedited treatment. And it's based on a showing of compelling need. And then the other requirements or standards really vary by agency. And you have to look at the specific agency regulations to see what each agency considers a compelling need that justifies expedited treatment. But generally speaking, the broad requirements that apply across agencies are that if the request is not expedited, the documents, a failure to get the documents would pose an imminent threat to life or safety. That one is rarely invoked and rarely at issue. The more common basis that is asserted is that there's an urgency to inform the public of a federal government activity by someone who's engaged primarily in disseminating information. That's the typical basis for requesting expedited treatment. If a request for expedited treatment is granted, it doesn't mean that you get the records immediately. There might very well be a third queue of requests that have qualified for expedited treatment. You might still be in a line, but you're in hopefully a shorter line that's going to move more quickly. The other factor to consider is that When a request qualifies for expedited treatment, the statute only requires that agencies process the records as soon as practicable. And what's practical is going to vary based on a host of factors. It includes factors like how many other FOIAs are in front of yours, how many FOIA litigations the agency has, how many court-ordered production schedules the agency's under, how much staff they have, and other kinds of factors like COVID or other things that may be happening at the agency. The other thing that is often determined at the outset when the agency responds to a FOIA request is what fees will be charged. For a typical requester, agencies are permitted to charge fees for the time it takes to search for records and for duplication costs. It's often after the first 100 pages or so, or the first 2 hours of searching, that fees can be asserted or assessed. There are some particular categories of requesters that get a break on fees: educational or non-commercial scientific requesters and representatives of the news media. There are limitations as to what fees can be assessed as to those entities. But I think more common and more significant from actual FOIA practice is the availability of fee waivers for certain categories of requesters. Fee waivers can be available, which will either waive fees entirely or permit limited fees, where information is likely to contribute significantly to public understanding of the operations or activities of government and is not primarily in the requester's commercial interests. If the requester is seeking the records principally for a commercial interest, it's very unlikely that fees would be waived. And in fact, that's the situation where fees are most likely to be assessed. Again, agency regulations vary on this point, and it's important that you put a request for a fee waiver into your FOIA request if you are hoping to avoid the assessment of fees. I will say that one of the more recent amendments to FOIA made clear that agencies that fail to meet their deadlines cannot assess fees absent unusual or exceptional circumstances. So that's actually quite important because in many, many cases, given the backlog, the volume of requests that agencies are receiving, they're not meeting their FOIA deadlines, and so they're not actually assessing fees ultimately. So that was a provision of the law that really changed fee practice pretty substantially.
I'll say from my perspective, of course, I'm always a news media requester, so that helps. But from my perspective, at the federal level, fees are a non-issue. It's not true at the federal and state level, at the local and state level, it's not true. But at the federal level, from my perspective, fees, non-issue.
Yeah, I think if you're not a member of the media, it becomes a more significant issue. So once the agency has acknowledged the request, made a determination of whether it's going to comply, and once it's determined whether the request is eligible for expedited treatment and fee determinations, the agency, the request goes into a queue, and when your turn comes up in the queue, the agency will conduct a search for responsive records. There's a lot of litigation, a lot of case law about what constitutes a proper and adequate search for records responsive to a FOIA request. And the bottom line is that the standard is just reasonableness. The agency has to conduct a reasonable search and what that means is that the agency has to look in the places within the agency, in the offices with the custodians where records are likely to be found. If a record is likely to be, a responsive record is likely to be found in the email system, it needs to look there. If there are likely to be records on the network that are responsive to the request, the agency needs to look there. But the researches don't have to be perfect. And it often happens in FOIA litigation that a requester, let's say a journalist, will say, hey, I have this document that I got from some other source, and it should have come up in the agency's search because it's obviously responsive to the FOIA request, but the agency didn't produce it, and that shows that their search was inadequate. That argument typically does not work because searches do not need to be perfect, and they do sometimes miss responsive records. That said, if you do have a record like that, that you can flag for the court and for the other side, it can be quite persuasive in persuading the agency during the negotiation period that, hey, this record wasn't found. Tell me more about your searches. Why wasn't this record found? Was it because you didn't look in the right office? Was it because you didn't use the right search terms or use a reasonable set of search terms? So it can be a very helpful fact to have in challenging an agency's search, but it's not determinative just because a document was missed. Just because records under FOIA are very broad and include electronic records, searches must also include electronic information. The agency generally has discretion to formulate search terms to do those electronic searches, but again, reasonableness is the standard, and agency search terms have to be reasonable.
Sarah, this is a little embarrassing for both me and the Department of Defense, but I once requested a specific Department of Defense report, a very specific by title, got a no responsive records response from DoD. Then I discovered that the report was just published on the open web on the Department of Defense website.
Yeah, that is embarrassing times two, but not a surprise. Not a surprise. So, there are many circumstances in which agencies either don't respond to a request because it's still sitting in the queue, or respond in a way that either withholds records, gives you very redacted records, or provides a much smaller set of records than you think are responsive. You then have the opportunity to go to court, and a district court has jurisdiction to order the agency to conduct an adequate search and to produce records that have been improperly withheld. There are a number of benefits of filing a lawsuit. It does effectively bring you to the front of the queue, or at least closer to the front of the queue. Agencies, as we said, are processing records in the order processing requests in the order in which they're received. But once a lawsuit is filed, you have the court involved. The court is going to set a schedule for the agency to complete a search and to process records, and the agencies understand that. So effectively, you jump the line if you file a lawsuit. If the lawsuit results in a change in the agency's position, the attorney's fees can be recovered. FOIA provides that if a requester substantially prevails, attorney's fees can be recovered, but substantially prevails is defined as a change in the agency's position. And so this can simply be a complaint. You file a complaint in district court, the agency then produces the record. Unless the agency can show that the record was effectively in the mail before you filed the complaint, you're going to be able to recover attorney's fees for that complaint that you prepared, because the agency changed its position. In other words, it looked for the record and it produced it in response to your lawsuit. The other thing that you can get in a lawsuit that's not available at the administrative stage is you can get a court to look at the records in camera, or at least you can request. You're not entitled to a camera review, but you can ask a court to review records in camera that you think the agency has improperly withheld on the grounds of an exemption. Where can a lawsuit be filed? It can be filed wherever the requester is located or has its principal place of business. If it's an entity, you can file where the records are located, and you can always file in the U.S. District Court for the District of Columbia. You must file a FOIA lawsuit within 6 years of denial, it's rare that you would get to a situation where that fact pattern occurred, because typically requesters are filing before they've even received a FOIA response from the agency. And again, there is a requirement of exhausting administrative remedies, but if the agency has missed deadlines, the courts will essentially find constructive exhaustion, and you can go to court in that instance.
Sarah, I've gotten a question in the chat that feels related to the issue of where you can file. Someone has asked where it's best to file, and specifically, is it better to sue in DC since they handle a lot of FOIAs and presumably know the law, or outside of DC? And this person says, I know the Northern District of California used to be good for FOIA cases.
So it's an excellent question. I would say, so I practiced in the SDNY exclusively, and most, obviously the requesters in that case chose to file because, or I shouldn't say obviously, they chose to file in SDNY because typically that's where the plaintiff was located, the requester was located. It used to be the case many, many years ago, decades ago, that the District of Columbia was really the go-to location because the statute permits really any FOIA case to be filed there. And they did get so many cases there that there was a perception that the DDC was the place where you would get a bench that really understands FOIA. Over the past 20 years or so, FOIA lawsuits have really become much more common in other jurisdictions. SDNY is a very, very common jurisdiction where the requester lives in New York or Connecticut or in the SDNY area. In the SDNY jurisdiction, rather, not in Connecticut. I was thinking of Mafia being in Connecticut, but the plaintiff, the requester himself or herself, actually is often in New York. Northern District of California was also a very common place for FOIA requesters to file. And I think there was a perception at a time that was a friendly place for FOIA requesters. I think, you'd really probably, if you ask 10 people, you might get 10 different answers. But I do think there, at least in SDNY, EDNY, California, you've gotten a level of expertise on the bench there that really rivals the District of Columbia. Although in the District of Columbia, they get an extraordinary number of FOIA cases, almost, to the point of, making it difficult for the judges there to handle their dockets. So once you file a lawsuit, how does it typically proceed? It starts like any lawsuit with a complaint. In the FOIA context, a complaint can be very, very bare bones. It really just has to recite that you filed a FOIA request, recite the history, the agency didn't respond, and assert a cause of action for records improperly withheld. It can be very, very bare bones. Of course, you do see more detailed complaints where the requester will explain, the public interest associated with the request, but that's not generally required. The government has to respond to a FOIA request within 30 days, which is short for the government. Typically, the government has 60 days to respond to a FOIA request, but in the FOIA context, 60 days to respond to a complaint, but in the FOIA context, the government has 30 days. In lieu of an answer, sometimes the government will move to dismiss the FOIA complaint, but on legal grounds, but that's quite rare. It's typically if there's a failure to exhaust administrative remedies, or possibly if the FOIA request was submitted to a non-agency, an entity that's not an agency. Once the pleadings are submitted, the next step is for the court to hold an initial conference. This is under the Federal Rules of Civil Procedure called a Rule 16 conference in any kind of case. But in the FOIA context, it's really a fairly simple process. The court will issue an order identifying a conference date and typically asking the parties to submit a letter before the conference telling the court what the case is about, what the issues are likely to be, and how the parties think the case should proceed. In FOIA, unlike in typical civil litigation, there's generally speaking no discovery, no depositions and other things. That can happen in very rare cases, but in general, the way a FOIA case proceeds is, let's take the situation where the agency hasn't responded and produced any records. Basically, the parties will then meet and confer. They'll try to come to a meeting of the minds on, what the scope of the request should be. Joshua mentioned earlier that he would sometimes narrow the request in the administrative process. That also happens in the litigation process as well, where you have a broad request and the agency will say, look, this is either too broad, it's going to take forever to process, how can we narrow it? Or we don't quite understand what this request is really seeking, how can we clarify what the scope is? And those discussions are really very important at the outset of a case, because the parties then go into the court and say, here's our schedule, our proposed schedule for how the case should proceed. Now, sometimes the parties can't agree. The requester might not be willing to narrow the request, or the agency might say, well, we're going to produce records on a rolling basis at 500 pages per month, and the requester says, no, we want the agency to do 1,000 pages per month. In that case, the parties will report to the court their disagreement, and the court will resolve that disagreement and enter a scheduling order. Typically, it will require rolling productions, certain number of pages per month. That will go on for however long it takes to complete the productions. Again, throughout this whole process, there's a lot of discussion and negotiation between the parties. Once the agency starts producing records, the requester is receiving the records, might notice there are redactions on the records for information that the agency has identified as exempt from disclosure. There would still be discussions about, what can you tell me about what kinds of information this is? Why is it exempt? And the idea behind that and the reason for those negotiations and discussions is to try to narrow the issues. In some cases, the requester might be able to persuade the agency to lift some of the redactions, or the agency might be able to persuade the requester that, oh, okay, this is information that's privileged or classified and it's not worth challenging. But once the issues are narrowed, if there are still disputes over either the adequacy of the agency's search, the agency only produced 100 pages of records, but we think there's a lot more responsive records out there, or the agency produced 100 pages of records, but they were very heavily redacted, and I'm not persuaded that the exemptions apply so broadly, then those disputes are typically resolved through what's called summary judgment motion practice. So that's a motion where the agency will put in declarations explaining why it believes it conducted an adequate search and why any information that's been withheld is subject to an exemption. And then the plaintiff has an opportunity to oppose that and say, here are all the reasons why the search wasn't adequate. Here's why we don't think the exemptions apply. And the court will decide that. Again, it's very rare that there would be discovery or a trial in a FOIA case. It's typically decided on the basis of declarations.
I just want to say those declarations in agency motions in FOIA cases, if you're a real FOIA nerd, or if you're if you're a reporter and you're covering a specific agency and you really want to get in the weeds, those declarations are a rich source of information on what kind of records the agency has, what kind of databases or systems of records it has, how it maintains those records, and they can be really great for crafting future FOIA requests.
The vast majority of cases, I would say, in my experience, are resolved through settlement. Many cases do go to summary judgment, but overall, many more cases are resolved with the agencies producing producing records over a period of time. There being discussions between the agency counsel, between the counsel representing the agency and counsel representing the requester about, whatever information was withheld and what information can be provided. And I think, it's certainly not rare to have summary judgment practice and a court decide, but there's a lot that can be done in terms of resolving cases through settlement and negotiation. Oops. Wanted to give one example of a case that was a recent case where the negotiation was unsuccessful, and I think this is a bit of a cautionary tale. This was a FOIA request about what was called a mass migration event in Texas that took place in September 2021. There were 14 or 15,000 Haitian migrants who crossed into the United States in Texas, and they were detained by components of the Department of Homeland Security in Texas for about 3 weeks in September of 2021. On October 1st of 2021, an organization called Haitian Bridge Alliance and a number of other organizations filed a very, very broad FOIA request that contained 72 specific subsidiary requests. And I gave you just 2 examples of how broad these requests were. They sought all records related to or reflecting actions taken by the agency or agency personnel in response to the arrival or presence of migrants, and all records related to or reflecting the provision of temporary housing, medical care, food, water, clothing to the migrants. So you can see, if you're a FOIA staffer who gets this request, that is extraordinarily broad. All records about all actions taken by the agency on these various topics. The agency responded in January of 2022, so just a few months later, that portions of the request were overbroad and didn't reasonably describe the records, and asked the requester to clarify those portions. The requester didn't resubmit anything, but instead filed a lawsuit. The parties then negotiated for over a year, and even after a year of negotiation, during which regular status reports are being given to the court every 30 or 60 days, they still had 14 requests that they couldn't agree on. So then there was motion practice about whether those 14 requests reasonably described the records at issue. And in February 2024, the court said they didn't reasonably describe the records that were requested. The court basically found that an agency employee familiar with the subject matter would not be able to locate the records with reasonable effort based on the request, and it would require a review of a vast amount of material in order to locate the potentially responsive records. So essentially, you have a situation where, even though the FOIA request was filed very, very shortly after the incident, the event at issue that they wanted to learn about, it was so massive and so broad that, and then the parties were not able to narrow the scope, so that more than 2 years later, the plaintiff still hadn't gotten any records. And I'm told that this particular case, records are still being produced, so it's even longer. This kind of scenario, it's not uncommon, but I think it's a good example of why the broad requests often are just really not that useful in the FOIA context. You could litigate for years and then be told your request was overbroad to begin with, and you don't get anything in response to that request. So we've talked about the FOIA exemptions, and FOIA has 9 exemptions that allow the agency to withhold records. Generally speaking, FOIA has a presumption of disclosure. The default rule is that you're entitled to agency records unless they fall within one of the 9 exemptions. The burden of proof is on the government to show that a particular information or a record is exempt. And there's something called a segregability requirement, which means that if you have a record that contains both exempt information and non-exempt information, the agency has to segregate the exempt material and produce the rest. So this happens, for example, you could have a record that's classified, and classified records according to the executive order on classification, have to be portion marked so that each paragraph has to be portion marked, classified, unclassified. If you have a document that contains unclassified paragraphs and classified paragraphs, an agency couldn't just withhold the whole thing as classified. It would have to segregate out, or redact out the classified paragraphs and produce the unclassified paragraphs if they're not subject to another exemption. There is, however, an additional requirement that is a requirement that was imposed in the 2016 FOIA amendments, which requires, in addition to establishing that an exemption applies, the agency has to go further than that and show that the disclosure of the particular document would foreseeably harm an interest protected by the exemption. The only time that the agency doesn't have to do that is if they claim something called Exemption 3, which means that the disclosure is prohibited by some other statute. Otherwise, not only do they have to show that the exemption applies, but also that the interests behind the exemption are implicated. So I'm going to just zip through the various FOIA exemptions so that we can get to some questions. The first exemption is for classified information. Classified information can be withheld under the FOIA if the information is specifically authorized under criteria established by executive order to be kept secret in the interest of national defense or foreign policy, and the information is in fact properly classified pursuant to the executive order. The executive order that currently applies to classified information is from 2009. It's EO 13526. Essentially, what this order requires is that the government demonstrates that the information, one, falls within a category of information that can be classified, for example, intelligence sources and methods or military plans. And two, the agency has to show in a reasonably specific way that disclosure of the information would cause identifiable harm to national security. We mentioned a GLOMAR response earlier. Sometimes it's the case that the government will say that we can't even respond to your FOIA request because whether or not responsive records exist is itself a classified fact. So, for example, if you were to file a FOIA request of CIA saying, is Joshua Eaton an intelligence source, they would undoubtedly respond by saying whether, they wouldn't say yes or no. They would say, we can't tell you that because whether or not responsive records exist is classified. And they would do that because whether or not specific individuals are sources is, fundamentally the type of information that can be classified.
And reading too much into one of those GLOMAR responses is definitely something I've seen people do before.
For sure.
We just got a question in the chat related to the confidential or classified information exemption, which is, does the information already have to be classified at the time of the FOIA request, or can the agency sneak around FOIA by classifying it retroactively?
So agencies can classify information retroactively, but it is very hard to do that. By agency regulation, typically if information is going to be if the agency wants to classify information that is subject to a FOIA request, it has to typically go to be classified at a much higher level. So this happened in a couple of FOIA cases that I was involved in, where both of them happened to be Department of Defense cases, where at the time the FOIA request was filed, particular information was not classified. However, in the course of reviewing, conducting a search and reviewing the records, an official classification authority said this information should have been classified. And so then what happens was the issue had to be teed up to actually the Deputy Secretary of Defense level, according to the DoD regulations in order to classify that information. So it can be done, but it's very rare and it's difficult for the agency to accomplish. Typically, there are additional procedures that are intended to preclude the situation where agencies are just doing this retroactively without support. It's really quite a big deal to do it. There's one other caveat to that, which is information can be classified, but not correctly marked as classified. So agencies will have what are called classification guides that identify categories of information that are classified. So for example, you could have a DoD classification guide that might say that certain kinds of information about IEDs that are used in the field of combat is classified. And then you could have a document that contains that specific kind of information about IEDs that a Department of Defense official neglected to stamp as classified or mark as classified. That information is properly classified because it's been classified and it's within the classification guide, but the improper marking doesn't render it non-classified. So that's just a little bit of a nuance when it comes to classified information.
And there is, oh, I'm sorry. I was just going to say there is something called mandatory declassification review, which is a whole separate process. I have not personally requested a mandatory declassification review. I know other FOIA requesters who have, beyond the scope of what we're talking about today, but it is a thing that exists.
Yeah, and agency regs, again, will govern that process. Generally, you can't do both FOIA and mandatory declassification review. You have to choose, but that is an alternative route to take when you know that there's a record that's classified. In my experience, it takes quite a long time. You're likely to get let me put it this way. If you go through FOIA, you're probably going to get a faster response, but the mandatory declassification might get sort of a deeper level declassification review. Because keep in mind, under FOIA, the question is whether the information is currently and properly classified under the executive order. The different question is, under mandatory declassification, the question is whether it should be declassified. So it could be properly classified, and an agency official should nevertheless decide it should be declassified. Generally, if the agency makes a detailed showing, a reasonably detailed showing, courts are deferential to the agency's determination of whether harm is likely to flow from release of information. The standard in court is whether the agency's showing is logical and plausible, which is a fairly easy standard for the government to meet as long as it doesn't rely on conclusory statements and provides a reasonable description. Exemption 3 is information that's exempted from disclosure by another statute. There's a long list of statutes that apply. Some examples are grand jury information, which is covered by Federal Rule of Criminal Procedure 6E. The Internal Revenue Code prohibits disclosure of tax returns. The National Security Act has a prohibition on the disclosure of unauthorized disclosure of intelligence sources and methods. Virtually many of the intelligence agencies have their own statutes that apply to records from those agencies. If the information falls within the scope of that statute, it can be withheld under Exemption 3 of FOIA. There's no foreseeable harm requirement when it comes to Exemption 3 statutes. That's because Congress has already determined through this other statute that the information should be withheld. There is a requirement that the other statute either require withholding with no discretion or establish criteria for withholding. And if it's enacted after 2009, the law has to say that it's an Exemption 3 statute. Exemption 4 talks about trade secrets, confidential commercial or financial information that are provided to an agency by a person or a third party. This is often information that regulated entities provide to the government, to the regulator, information that they need to provide to the regulator for purposes of that regulator's performance of its duties, but the information is confidential because it would reveal some, confidential financial or commercial information of the submitter. The trade secrets category is very, very narrow. We're really talking about things like the formula for Coke and that sort of thing. But the category of confidential commercial information is very broad. There was a decision by the Supreme Court in 2019 called Argus Leader that basically says this exemption applies to anything that a business customarily keeps confidential and is provided under an assurance of confidentiality. The agency must still show that releasing the information would foreseeably harm the commercial and financial interests of the submitter. That's true of all the exemptions other than Exemption 3. Exemption 5 is a big exemption. It's one that comes up quite a lot, perhaps more than any other. It's basically privileged materials. It's any inter or intra-agency, any intergovernmental letter or memo that would not be available by law would not be available to a party other than an agency in litigation. In other words, if the agency was in litigation with you, the agency could withhold it. So it applies to attorney-client privilege materials, work product. A very common privilege asserted by the government is something called the deliberative process privilege, also known as the executive privilege. That applies to information that's pre-decisional, meaning information before the agency reaches a final decision, and is deliberative. In other words, it bears on policymaking, and it's not purely factual. One of the recent amendments in 2016 to FOIA basically imposed a sunset provision where a deliberative process privilege expires after 25 years. This privilege, like most privileges, or this exemption rather, like most privileges, can be vitiated, will evaporate if the privileged information is provided to third parties. So, if it's no longer inter or intra-agency, it's not going to qualify for the privilege. There's an exception if it's given to a government consultant who's basically acting as the government's agent. But generally speaking, disclosure to third parties is going to make Exemption 5 evaporate. This is an area where the foreseeable harm requirement is very, very important, particularly as to the deliberative process privilege. The 2016 amendments to FOIA, the legislative history makes clear that the deliberative process privilege was something that the legislators had particularly in mind as being overused or overasserted by the government. And so the foreseeable harm requirement was intended to require the government to make a showing that it really is necessary to withhold information under the deliberative process privilege in order to ensure that the government can make good decisions. Essentially, what we're talking about is a privilege that protects agency personnel so that they can be candid and upfront in the course of making government decisions. The worry is if agency personnel have to produce drafts or recommendations that they make to their superiors, there's going to be less candor in government decision making, and that will ultimately make government decisions poorer overall. And now with the foreseeable harm requirement, the government really has to show that in this particular context and with these particular documents or types of documents, disclosure would be harmful to that interest. This is an area I think that FOIA requesters should really look to as an area to expand the type of information that the government can be producing.
Deliberative process has gotten the nickname the "because we wanna" exemption for how frequently it's employed.
Yeah, it is employed quite a lot, but you'll see the case law that's arisen under the recent amendment, 2016 amendment, is really holding the government to its burden to show that disclosure would in fact be harmful.
While we're between slides, I wanted to just jump in real quick and give the promised 15-minute warning. I think we should probably plan to wrap sometime around 8. So I know we got a few more slides left and a couple questions in the hopper. I know we've been going through questions sort of throughout, so just so we're aware of timing for folks in the audience, and that's what we'll plan for.
Thank you, Stacy. FOIA has 2 privacy exemptions. Exemption 6 applies to personnel and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. And then there's a separate exemption, 7C, which applies to law enforcement records, the disclosure of which could reasonably be expected to constitute an unwarranted invasion of privacy. So exemption C is a little bit more weighted in favor of privacy than exemption 6. And I should note that even though exemption 6 refers to personnel and medical files and similar files, the concept of similar files has been very, very broadly interpreted by the Supreme Court. It applies to basically any information that relates to is identifiable to an individual. So exemption 6 applies much more broadly than just personnel and medical files. FOIA, generally speaking, takes a very broad view of what privacy means. It's anything that relates to an individual. It's anything that it's material that an individual would generally not want to be made public about oneself. It doesn't require a showing, for example, that there be a reasonable expectation of privacy. That's a Fourth Amendment context. It's just information that relates to the individual. Only natural persons have personal privacy interests. So a corporation, for example, can't assert privacy, or the government can't assert privacy on behalf of a corporation. Generally speaking, deceased persons do not have privacy interests. However, there are some cases where agencies have withheld information about a deceased individual that would invade the privacy of family members. So one example of this is the voice recording of the Challenger crew's last moments before the explosion. The transcript of that voice recording was made public by the agency, but the agency withheld the actual recording of the voices of the Challenger crew on the basis that it would constitute an unwarranted invasion of personal privacy, thinking about the family members of the crew. Another example was the Supreme Court issued a decision called Favish, which protected on privacy grounds the photos of former Deputy White House counsel Vince Foster, who committed suicide. There were photos of his death scene that were protected under Exemption 7C. So although there's generally a rule that privacy doesn't apply to deceased individuals, there may be exceptions to that rule.
Also, confidential law enforcement sources, typically, even after they're deceased, for some period of time after that exemption would apply.
Interesting. Okay, I haven't seen that under the privacy exemption, but there is also a separate exemption for confidential sources. If the agency does identify a more than de minimis privacy interest, so really any substantial privacy interest, then the agency has to balance that privacy interest against the public's interest in disclosure. And in FOIA, although the privacy interest is quite broadly interpreted, the public interest is very, very discrete. The only relevant public interest for FOIA purposes is shedding light on the agency's performance of its statutory duties, or also articulated as letting the citizens know what their government is up to. So there might be a sort of general public interest in a particular piece of information, but if that interest isn't going to shed light on how the agency does its job, that might not be a public interest that matters for FOIA purposes. Oftentimes, just practically speaking, Redaction of personally identifying information in documents will resolve the privacy concerns. And personally identifying information can be, obviously name, date of birth, social security number, those kinds of things, but it can also be broader than that and just relate to other pieces of information about an individual that would allow that individual to be identified. Exemption 7 is for records compiled by law enforcement purposes if disclosure would cause one of various enumerated harms. 7A relates to disclosure that would interfere with enforcement proceedings like a criminal investigation or a prosecution. 7B relates to depriving someone of a fair trial or an impartial adjudication. That one's very rare. We talked about 7C for privacy. 7D talks about the identity of a confidential source. 7E, and that could be asserted even if the person is dead. I mean, that's an assertion that is both to protect the source and to protect the agency. Exemption 7E talks about protects techniques and procedures for law enforcement investigations or prosecutions. It also protects guidelines for law enforcement investigations or prosecutions. And then finally, 7F protects information that could reasonably be expected to endanger someone's life or physical safety. Generally speaking, the compiled for law enforcement purposes threshold requirement of Exemption 7 is relatively easy for an agency to meet. The agency just has to identify a nexus to law enforcement. But again, the agency has to articulate a foreseeable harm from disclosure. Requesters should think about questions like, is the investigation closed? If it's not pending or reasonably anticipated, then the agency isn't going to be able to withhold information under 7A. Under 7E, when you're talking about law enforcement techniques, requesters will often make the argument that the public knows already that these techniques are in use, they're well-known techniques, and therefore they can't be withheld. The court has to look at that question. It's true that well-known techniques can't be withheld under the FOIA, but at the same time, the details of how an agency uses well-known techniques. So it's well known that the FBI might use certain technology to listen in on phone calls with a warrant, but the precise details of how they do that and in what specific circumstances and whose phone calls and the like, those details may still be protected. There's some exemptions you'll notice I didn't address that are rarely asserted. Exemption 2, internal personnel rules. Exemption 8 has to do with documents relating to the supervision of financial institutions. And Exemption 9 has to do with geological information about wells. I think in my 25 years at the U.S. Attorney's Office, I had one case on Exemption 8 and one on Exemption 9. And really, Exemption 2 used to be interpreted more broadly, and so there used to be Exemption 2 cases, but the Supreme Court very narrowly interpreted in a case called Milner. So those cases, that is rarely asserted anymore.
So very quickly, we've already gone over much of this. Every state and DC has its own public records laws. State laws apply to counties, municipalities. They also often apply to quasi-governmental agencies like irrigation districts, water districts, things like that. State laws can vary widely. Many provide access to governor's records, certain judicial or legislative records, different procedures for submitting requests, agency deadline to respond, options for appealing a denial. Those all differ from federal law, often less developed case law. Compared to federal FOIA, state, local FOIA response times are often much shorter. There are 9 states: Alabama, Arkansas, Delaware, Georgia, Missouri, Tennessee, and Virginia that have some form of residency requirement. In my experience, those residency requirements are enforced kind of when they want to enforce them. The next slide is resources. I know we're short on time here. Would encourage y'all to just, I'm not going to go through all of these. They're great resources. Would encourage you to just screenshot this to come back to later. Same for the next slide, which is I have 2 tip sheets. One is how to find records with a FOIA request. One is how to find records without a FOIA request. Goes into things like court records, tax assessor records, a whole list of other stuff. Feel free to screenshot those and go to those bit.ly links.
Amazing. Okay. Well, thank you both so much for that great presentation. I know we've been doing questions throughout, but if anybody in the audience has a question that they want to send through and have us talk about, there are a couple that I've been saving for the end. I don't know, Joshua and Sarah, if you want to just click the Q&A. There's one in there, Sarah, about your future plans post-GOJ that I think you can decide whether you want to answer. But one of the questions I've been reserving because I think it's covered in some ways throughout the presentation. It's just how long does each step take? And of course, that's an answer that's going to vary significantly from agency to agency. But Joshua, I thought it was really helpful for you to say that it was, following up promptly is something that people should prioritize. And so I'm wondering if maybe, Joshua, you can give an answer for the state level, or maybe just for Connecticut. You don't have to answer for all states. And Sarah, you can give just a very basic overview. How long does everything take, and how often should people be following up?
I've had even a state agency before take months to get back. It was clear they hadn't even looked at my request for months. And then when they did look at my request, they were like, we don't understand this request. And I was like, could have told me that months ago. So being able to the next day or a couple of days later, get somebody on the phone and just get their eyes on the request. If you can, if that's possible. It's not always possible at the federal level anymore. It's not even always possible at the state level. But if you can do that, it's a really great practice just so they can set eyes on your request. And if there are any of those initial confusions, once I filed a request, I was looking for any all staff emails that had gone out in a particular office, and they had interpreted my request as requesting all emails that went to all staff, which is decidedly not what I was requesting. So anything like that you can clear up from the get-go, very helpful. And then after that, once every couple of weeks, set yourself a calendar reminder. And be persistent, but be polite, and don't harass them.
Mm-hmm. First date,
until it gets time to harass them.
When it comes time to try to get someone on the phone, who do you even call? Who is the contact person that you're usually calling up?
Federal agencies will have a FOIA liaison. I found that it is increasingly impossible to get the FOIA liaison on the phone. That varies from agency to agency. They always have an email at the very least. Cities, it's, call around until you find the right person. Often at the state, in the federal context, there's a bit of a firewall between the press office and the FOIA office. That's often not the case at the state and local level. And because journalists file a bunch of FOIAs and the press office deals with journalists, the press office will at least know who to direct you to. So I sometimes will call the PIO and our public information officer or the spokesperson, whoever the case may be, and say hey, I filed this FOIA, who do I ask about it? Also, for journalists, another technique I will sometimes use is at the federal level, particularly where there is that firewall. Sometimes I'll file a FOIA for something, and then at the same time, I'll send an email to the press office and say, hey, can you just voluntarily give this to me? And, doesn't always work, but miss all the shots you don't take, so.
My answer is unfortunately going to be really unsatisfying because there's just really no way to generalize as to how long a FOIA request will take. If the FOIA request is 72 parts long and really broad and not easy to for a FOIA processor to understand, or is going to require broad searches within the agency, it's going to go into a complex queue. It's going to probably sit in that queue for a long time, and you may not get a response until you file a lawsuit. You could also have a request for just one specific record that's readily identifiable and findable, but the document implicates really difficult questions about what the exempt information is. I can recall a case that the New York Times and ACLU filed for a record that related, it was basically a presidential memorandum. The memorandum had been sent to the agency, so the agency had it. It was about the circumstances in which lethal force could be used against terrorists, essentially. And so it was a record that was not an easy record to process. It had to be reviewed for classification, for exemption 3. There was a question about was this record going to be subject to a presidential communications privilege? So you could have one record that still takes a lot of time to process. And then, on top of that, different agencies are very different. Some agencies have a much smaller backlog, and if you have a relatively simple request that can be answered quickly, they will do that. They would rather get that record out than have to deal with the all records relating to X topic type of request. On the other hand, if you have thousands of cases that are backlogged, you're probably going to sit in the queue at the agency. So it really varies. I mean, I hate to say that this as a former AUSA, but filing a lawsuit is really often the only way to prompt action where you have a request that's in a long queue where you haven't heard anything about it for months.
And there also there's really no rhyme or reason. I requested some records once. I'd requested records previously on detainee records on Abu Bakr al-Baghdadi, the former leader of ISIS. I'd requested his detainee records from the Pentagon from his time in detention in Iraq, early in the Iraq War. And I'd gotten them, but there were some redactions. Like the day that they announced that the U.S. had killed him, I requested the records again because I knew that some of those redactions might go away because he was now dead. And I knew the record, like where to file, what I was like naming the names of forms, like I knew very specifically what to request. And like 2 days later, they got back to me and I got a story out of it. And, I would never have guessed. No rhyme or reason sometimes.
Well, seeing no new questions in the chat, maybe that's a good place to leave it, but they're very lawyerly, it depends. But I think that even though sometimes there is no rhyme or reason to FOIA, there sometimes is a rhyme or reason to FOIA, and our two great panelists have, I think, done a really great job breaking down how you can start using it. The clinic is always here. I know a lot of people in the audience are probably part of the Yale community, either undergraduates or Yale law students or folks who live in New Haven. So look us up if you have more questions about FOIA. It is stuff that we work with every day. If we were in person, I would say please join me in thanking both of our panelists for their great presentations and for their time tonight. But no one can clap, so I will clap. Thank you so much. We really appreciate it. I'm going to stop the recording now. But everyone have a really great night.